This afternoon, we'll start. Can I have your attention, please? This afternoon, the program starts with a paper by Warren Mueller. But before I introduce Mr. Mueller, I thought I should remind you that we will have a panel this afternoon at approximately 4 o'clock, composed of Mr. Justice Linden and Mr. Grossman, Mr. Mueller, Professor Friedman, and Morris Manning. And there is a question box here. There was a question this morning, which was discussed at lunch, and hopefully there will be other questions. If you have them, I think you'll find in the material that was given to you a slip of paper which would permit you to ask a question. I notice there is a place on the paper for your signature. If that's what's holding you back, don't worry about it. It's not necessary the paper be signed, or if you've lost those slips, write out any questions you have on a piece of foolscap or any other paper that's handy and put it in the question box. That's not to say that we won't, that the panel won't field questions from the body, but it's much better if the questions are in writing, because then they can be repeated accurately to the audience. Now, having said that, this afternoon we have with us Warren Mueller. Warren is Queen's Counsel, admitted to the Bar of Ontario in 1969. He was educated at the University of Toronto, where he graduated with honors. He was also a graduate of the LLB course at the University of Toronto and the University of Michigan, where he obtained his Master of Laws. He has a gold medal in political economy. He's the editor-in-chief of Carswell's Practice Cases and the author of Law of Contracts in the Canadian Encyclopedic Digest. He's also the author of many other papers, which I will not repeat to you today, because I will not use his time for that purpose. He is presently practicing with the Outerbridge firm in the city of Toronto, and as I mentioned to Warren before we sat down, my memories of him are not very fond. I lost a case to him in the Court of Appeal about 6 years ago, and I've never forgiven him. But here he is this afternoon. Warren, thank you.
I don't think, Bruce, that was a products liability case, as we'd call it, but that's what we're here for this afternoon. The formal paper that will ultimately be available in written form is a lengthy one running to around 75 pages with well more than 100 footnotes. I shall try to give you the structure of the paper and give you a feeling for some of its contents and perhaps highlight some of the more interesting areas in the time that is available. The paper deals with what I term recent developments in the tort component of products liability. Recent being defined in this paper as a matter of 10 years, related to the fact that there exists in the lectures of exactly 10 years ago a very good paper by Reno Stradiotto, which covers the law up to that point from which I launch off. What I endeavored to do in this paper was develop a list of questions which might in some sense act as a checklist if one were endeavoring to be exhaustive as to the concerns that you would have to have in approaching a products liability case. And then I have used each of these particular questions as a focal point for developing the law that has emerged in relation to it. The first portion of the paper deals with problems of causation. And the first question, as I have posed it, would be, was there a defect in the product at the time when the plaintiff suffered injury or damage, and did such defect cause the plaintiff's loss? That particular problem is, of course, an age-old one. As early as 1905, and still a leading case, the Privy Council said that it was, quote, sufficient to adduce evidence from which the tribunal may fairly infer both the existence of the fault and the connection between the fault and the injury complained of. In a case that I argued in the Supreme Court of Canada 2 or 3 years ago, the Schreiber brothers case dealing with, in that situation, a breach of warranty of merchantability affecting roofing asphalt. Chief Justice Laskin, having posed the question as one of, quote, whether the existence of a defect in the asphalt when it left the supplier's plant must be shown affirmatively or may be proved by inference from the whole of the evidence, held, and again I quote, it was enough here that the plaintiff show that a defect existed when the goods were delivered by the vendor without being required to prove the cause of the defect. We never could. We didn't. Nonetheless, we succeeded because the product didn't work. Another illustration in this particular area involves a plaintiff who ordered some impact-resistant or Hard-X lenses for eyeglasses. He received ordinary lenses only. He sustained an eye injury. It was held that he was required to prove by inference from strength tests on the Hard-X lenses that, quote, the impact he experienced, although sufficient to break the ordinary and untempered lenses he wore, would probably not have been sufficient to break a Hard-X lens. The second question, as I would pose it, is, was the product defect caused by the manufacturer or by subsequent interference with the product by third parties? Here we deal with what you commonly know as intermediate inspection. While that term was originally coined to deal with the right of a manufacturer to insulate itself from liability by proving that it could reasonably have expected that the plaintiff or middleman or processors in the chain of distribution might examine the product and detect any defects, it has come to be used with respect to the possibility of such persons meddling with the product so as to convert it to a dangerous or noxious state. The time factor here can be a very significant one. I had some involvement with my associates in the Comstock and Edmonton Flying Club case. There, 27 years went by from the date of installation of a motor control circuit before a fire occurred. It was nonetheless held that there was no evidence of an intervening act that had in any way altered the original hookup to the power source, nor any evidence that the materials used in the original installation had been subject to any unusual wear and tear or depreciation of any nature that could affect the operation of the motor starter. I think one of the judges referred to it as sort of a time bomb sitting there ready to go off, and in the end result, notwithstanding 27 years from the date of installation during the wartime, liability was imposed on the original manufacturer. In a case involving a dead mouse being found in a bag of flour, notwithstanding the bag had been purchased for at least a month by the time of the discovery, the bag having been tied up in between, the trial judge paraphrased what then Professor Linden said in these words: the true meaning of the phrase reasonable possibility of intermediate examination is that it must be demonstrated that there's been no intervening cause, that is, no tampering or expectation thereof with the product by third persons so as to insulate the original manufacturer from responsibility. The leading recent case in this area is a Maritimes one, Smith & Inglis. There, a thermostat control in a refrigerator came in contact with a capillary tube, caused the cabinet to become electrically charged. Someone touched it, was electrocuted. There, dealing with this question of causation, the Chief Justice in Nova Scotia said, the inference that the manufacturer was responsible is readily made if the nature of the defect prevents it being disclosed by reasonable examination by the buyer. If such examination is not made when it could and should have been made, the buyer is inhibited from showing that the defect did not arise later. Conversely, if the defect is hidden from inspection, the manufacturer cannot blame the buyer for not seeing it and assuming the risk. A plaintiff must not only show prima facie creation of the defect by the manufacturer, but must also eliminate himself and other extraneous forces as likely causes of the injury, citing Fleming on torts. The third proposition or question that I put to myself on such occasions is, did any defect in the product cease to be a relevant causal consideration in the plaintiff's loss by reason of some subsequent unforeseeable negligent action by a third party? In short, the concept of novus actus interveniens. Once again, that case I referred to from Nova Scotia, Smith and Inglis, helps us here. There, a delivery man removed the third prong from an electrical plug. It was held, however, that this was a practice that electrical manufacturers ought to be aware of. The Chief Justice said in relation to this situation, provision of a safety feature clearly cannot exempt a manufacturer from his duty not to make an object with hazardous features, unless perhaps the safety feature were one which absolutely guaranteed safety, and one which could not possibly be removed or nullified. Certainly that duty still strongly rests on the manufacturer, whereas here he should anticipate the possibility of such removal or nullification, a possibility clearly within the ambit of the risk. As well with the Comstock case that I referred to, the one with the 27-year time gap, there the motor starter was produced by a company called Controllers for a company known as Comstock. Comstock was to use the controller in part of a more elaborate electrical piece of equipment. It was expected by Controllers that there'd be a proper hookup made of it, although the potentiality for improper hookup certainly existed and the plans were wrongly drawn. It was further expected or anticipated by Controllers that any problem in the hookup would be communicated to third parties, and it was further thought that there would be no intermeddling with the ultimate furnace controls by untrained personnel. Well, 27 years later, it wasn't the RCAF in wartime with proper engineers handling it anymore. It was people from an aircraft company that didn't know what they were doing, so confessed, were meddling. The fire happened, but Canadian Controllers was on appeal exempted from liability on the basis that they couldn't reasonably have foreseen that this set of circumstances and intermeddling would occur. The fourth type of question one asks is, did any failure by the plaintiff to take reasonable care for his own property contribute to his own damage? Obviously a question of contributory negligence. There are many cases dealing with individuals who smell gas from electrical appliances and whether they should or shouldn't realize that something is unusual is happening. One of the more interesting recent cases is the decision of the Ontario Court of Appeal in Heaney and Best. There, a truck struck overhead hydro wires. The plaintiff had not plugged in an alarm device which would have sounded a bell, told him there was a power failure, and enabled him to activate his auxiliary generator. Associate Chief Justice McKinnon said, in light of all the facts recited, the plaintiff, in failing to plug in the alarm device, failed in his own interest to take reasonable care of his property and so contributed to his own damage. The harm to his poultry by the interruption of power for any reason, including interruption due to the negligence of others, was foreseeable to a reasonably prudent man, and the appellant's failure to have his alarm device operating contributed to his loss. A very significant recent case is Tompkins Hardware and Northwestern Flying. There, the plaintiff continued to operate his seaplane, notwithstanding that he knew that some cords that were tied to prevent motion of the skis on the seaplane had somehow improperly been set up, as ultimately was found, negligently set up by a repair company. Because he continued to operate the plane, he was held liable to suffer a 20% abatement. He had, however, sued the repairer in contract and tort, and the question arose as to whether contributory negligence was available in the contract action, since in effect there was a warranty, would be a warranty of reasonable care in the workmanship. Mr. Justice Saunders said, the principle that where a man is part author of his own injury he cannot call upon the other party to compensate him in full has long been recognized as applying in cases of tort. I can see no reason why it should not equally be applicable in cases of contract. This was the substance of the obiter by Mr. Justice Krause in Canadian Western Natural Gas. I've been unable to find any authority that says otherwise, and in my opinion it makes sense. In such circumstances there should, in my opinion, be apportionment whether the action be brought in contract or tort. And he said the basis of apportionment would be the same. Having dealt with causation, the next area of questions that one examines in a products case is the bases and standards of liability. The first question in that area that I would ask is, do the facts permit the defendant to be held legally liable for causing the loss even though there was no fault or negligence on his part? That is, do we have a strict liability case? Rylance and Fletcher has been applied recently in aerial spraying cases with herbicides, in blasting cases, but something close to that has come to be seen in more mundane contexts. Mr. Justice Evans, in a case dealing with the supply of food, treats the standard as approximating absolute liability. Mr. Justice Linden, with an exploding pop bottle, treated the situation as somewhat the same. You get the next thing to strict liability without having it in legal theory. There was also one case in the last decade in the Court of Appeal, Diamond Waterproofing, in which dangerous inflammable materials were brought onto a construction site. They gave off vapors which were ignited by electrically operated heater from a spark. In that case, there wasn't, in the classic Rylance and Fletcher sense, any escape of the dangerous substance from one property to another. Despite the absence of escape, the Court of Appeal, without appearing too deeply to look into it, imposed liability. One may, I think, fairly ask whether a manufacturer distributing a dangerous product with knowledge that it must inevitably be used on the property of his customer might come under the same form of liability or restraint as with the individual defendant who himself personally brings the dangerous product onto someone else's property. The sixth question that I phrased is, did the manufacturer, by advertisement or otherwise, induce the customer to purchase the product from the distributor? Here we're dealing with collateral contractual undertakings. The most useful case is the decision of Mr. Justice Reed at first instance in Murray and Sperry Rand. There, a promotional brochure was disseminated through the independent dealer of a manufacturer, and it was held that the unfulfilled advertising claims, that is, the product didn't work like the advertising said it would, represented collateral warranties, and therefore there was strict liability for breach of the warranty. In the instance of a case involving the Bell telephone, where a user of a payphone was received an electrical shock, there a term was implied into the contract for using the payphone that it was reasonable to imply a warranty in the contract that the telephone equipment was reasonably safe for use by the plaintiff. Hence, recovery by the plaintiff, even though there was no negligence on the part of the telephone company. Seventh question, did the mode of manufacture or performance of the product fail to meet an applicable statutory or regulatory standard? Well, you're well familiar with cases involving breach of provincial statutes, national building code, and I've collected many of them. I thought the more interesting situation was whether you could use standards such as this to create a defense. That case, or that situation, arose in Kwong and the Queen, which ultimately went to the Supreme Court of Canada. There, a gas burner met the particular regulations of the Canadian Standards Association, which are imported into the Canadian Gas Association standards, which have been accepted by the governments generally throughout Canada. In the Alberta Court of Appeal, the Chief Justice at Alberta said, "In my view, there are no regulations governing warnings in respect to converted furnaces, and it is not open to the court to say that there should be. As I have mentioned earlier, regulations involve considerations of policy, expense, and effectiveness." On appeal to the Supreme Court of Canada, Mr. Justice Martland, in a brief oral judgment, said simply, "We are all in agreement with the conclusions reached by Chief Justice McGilvray that there were no regulations governing warnings in respect to converted furnaces, and that it was not open to the court to say that there should be." Therefore, those dealing with major institutions who are government regulated may find some difficulty in going behind that particular insulating barrier. I gave a smile to one friend in the audience. Paragraph 8, question. Did the manufacturer or distributor test the product to verify its quality and adherence to its advertising claims before distributing the product? Someone had the misfortune of turning out lenses advertised as impact resistant. They'd never tested them, and the court found that to be something more than negligent. The ninth question, was the accident inevitable given the particular product defect? Well, inevitable accident, a rather theoretical defense, because even with hidden defects, the courts have tended to suggest that, well, as with one case, the operator of a boat ought still to have averted the accident, notwithstanding that the boat operator didn't understand there was a defect in the control system for the boat. The third element, basic element or area of questions, relates to the proof of negligence. And the first question that one classically asks is, do the circumstances justify placing on the manufacturer an onus of disproving that it was negligent? In Ives and Clare Brothers, Mr. Justice Wright said that once it is established that injury or damages have been caused by the use of natural gas through an installation made, installed, or serviced by others, the onus of proving that there is no negligence is on the defendant who made, installed, or serviced the installation. I've often thought it was unfair to ask solicitors for the gas company to come forward and have to read statements like that, but nonetheless. The same situation applies with regard to, in effect, bottlers of soft drinks, or so Mr. Justice Linden has found in a case that I've given in my paper. The 11th question is, do the circumstances of the accident in and of themselves tend to prove that the defendant was negligent in manufacturing the defective product? Here we're talking essentially about res ipsa loquitur. A compendium of some recent cases to extract a portion of the paper indicates that the basic significance of the rule in products cases is that it has often been concluded that the defect in a particular product could not have arisen but for negligence on the part of the manufacturer. Typical is the following statement of a Nova Scotia trial judge, quote, "If the manufacturing process had been adequate, the axles should not have broken or the flexible lines ruptured. The fact that these parts did malfunction is prima facie supportive of a finding of negligence." Indeed, Mr. Justice Lerner, in a case involving a defective crown on a bottle of carbonated soda water, went so far as to say, quote, "Where the defect arises in the manufacturing process controlled by the defendant, the inference of negligence is practically irresistible," quoting Professor Wadhams. Either the manufacturer's system was at fault, or if the system was sound, then an individual employee must have been negligent. It's on that basis, in large part, that our Law Reform Commission has suggested that we have what amounts to strict liability in products cases in any event, although they wish to make it now explicitly so. There are a number of cases, however, and I've given you one involving a television set, the McLaughlin case, in which the courts still will say that res ipsa loquitur must not be used to convert alleged fault to strict liability. The control of the item has often been considered to be, in standard texts, an element necessary to the invoking of res ipsa loquitur to assist one. Mr. Justice Evans, however, in a case that's been applied on a number of occasions, has said, "It's sufficient to establish control if it is demonstrated that the servicing and repairing of the furnace was the exclusive province of the defendant and that no other agency intervened." The McLaughlin case cites the Fleming text to the effect that control during the process of manufacture is sufficient. Therefore, simply because it's sitting in the plaintiff's house, the article is for some considerable period of time, if he hasn't been responsible for repairing it or dealing with it, he may still look on a res ipsa loquitur basis to the manufacturer or the repairer. 12th question. Did the actions of the defendant manufacturer conform to the accepted standards or customs of its particular trade? In the instance of the supplier of propane equipment, one court in Murphy and Atlantic Speedy Propane simply said, as to the practice of the industry in not carrying out inspections where an appliance has been inactive for a period of time, it is my opinion that the industry is negligent and should change its practice, so that, therefore, custom of the trade is by no means a sufficient defense. The 13th question. To what extent will the findings of the trial judge with respect to matters of expert evidence be immune from attack on appeal? I've given you a couple of recent appellate decisions in the text which suggest that since the expert is dealing with inferences rather than direct observational facts, his reliance on his opinions ought to be capable of being attacked on appeal. But I must say that those who tried it opposite me and Schreiber Brothers found it to be difficult at the Supreme Court level, notwithstanding that Mr. Justice Weatherston in the Court of Appeal said that our theory was, on the evidence of the experts, quote, incredible, unquote. The Supreme Court of Canada didn't care. We won. Part D of this paper deals with duties of care with respect to the use of words. I won't bother to deal with the obvious cases which relate to my 14th question, did the manufacturer misdescribe his product or otherwise mislead his customer as to its use? There you're dealing with misrepresentation. I would, however, like to dwell to some extent on my 15th question, which involves one of the two main areas of interest in this area of the law in recent years, the duty of warning. Did the manufacturer fail to give its customer or the user of its product an adequate warning as to how to use the product and as to the dangers or potential problems of which the user ought to be aware? You get three levels in the first instance. One, the manufacturer has actual knowledge of the defect in the product. Too bad, manufacturer. Secondly, he's reasonably aware of the possibility of such a defect in light of his discovery of similar defects in some of his stock. That, of course, is the classic Rivtow type of, or in fact, that even precedes Rivtow. Rivtow represents a situation where the manufacturer learns only after the distribution of the product that it contains a defect. However, at the Rivtow case itself spoke only of actual knowledge of the defect in terms of a duty to warn. In the recent British Columbia Court of Appeal case of Kaminko and Westinghouse Canada, an objective rather than a subjective test has been applied. That is, the Court of Appeal said that the test seems to be one of ordinary negligence, that is, whether the manufacturers knew or ought to have known of the danger. That's a very clear extension from what was said in Rivtow, where actual knowledge was insisted upon. One must then be concerned with the scope or extent of the duty to warn. You'll know that in Lambert and Last Duplex, the Supreme Court of Canada required a very, very high duty with respect to the flammable product that was used on flooring in that case and led to ignition when there was a spark in another room. That high standard has been applied in other cases. In Lebrec and Saskatchewan wheat pool, a herbicide was distributed. It was suggested that one avoid deep planting, but the manufacturer did not, in his warning, make clear that the regular method of planting, as deep as it was, wouldn't work with this particular herbicide if used with flax. He was held liable for failure to warn. I'd note in passing that it's necessary to demonstrate before the defendant may be held liable for failure to fulfill a duty to warn that the giving of a warning would have influenced the plaintiff or otherwise averted the accident. And I've given you several cases where the courts have concluded that the particular plaintiff would not have listened to the warning or adhered to it in any event, and in such circumstances, the lack of warning does not help the plaintiff. In a case that I think is perhaps somewhat questionable unless you narrow it to its facts, in Irvine and Avoco, it was suggested that the Lambert decision of the Supreme Court of Canada was not applicable with respect to other than dangerous products. It was held that the duty didn't apply to safety glasses as they weren't items of a hazardous nature. With respect, I think the decision's wrong, or that one must read, and I've given at great length in the paper some bases for distinguishing the case on what was in fact said. One of the important decisions is the Alberta Court of Appeal decision in George Ho Lem. There, the points were made that the plaintiff was to be fixed with knowledge of the contents of the owner's manual relative to warnings, that the manufacturer had a duty in such a manual to point out the dangers of reasonably foreseeable product misuse. Thirdly, that there was a duty that the duty to warn extended to the distributor or seller as well as the manufacturer. And lastly, that there was no warning that need be given in respect of obvious dangers. One of the matters that's long interested me is the situation of the sophisticated or trained product user. And I have given you here some instances where either an engineer or a person in business really ought to know that you don't use a particular product in a certain way. It should be common knowledge in the trade. And in those cases, the defendant has exculpated itself by saying, look, plaintiff, you were a bright enough fellow yourself to understand that you shouldn't have used the product that way. Don't go looking to me and complaining that I didn't warn you about that particular hazard. It was well known. But you can't extend that too far, because in the case of doctors, Mr. Justice Linden, in the case of Davidson and Connaught Laboratories, has noted that while there is, in some situations, a less strict standard in communicating with experts, he said that a drug company cannot rely upon doctors to read all the scientific literature outlining the specific dangers involved in the many drugs they have to administer each day, and therefore, notwithstanding that you were dealing with the medical profession who you might expect to be somewhat knowledgeable on drugs, the onus was very heavily on the laboratory manufacturer to list in its literature all the side effects that could be anticipated. Unfortunately, in the specific case, it was indicated the doctors wouldn't have paid attention in any event, and so the drug companies went free on that point. Then there is an interesting situation. What happens when you tell the fella, don't use the product this way, but he's told you he's going to do it anyways, and you still sell the product to him? You're liable. Or so is the finding in Murphy and B&B Holdings Limited. They're extracting from the decision of the Nova Scotia Appeal Division. In such a case, to give a warning not understood or as here rejected is not enough. The supplier must not transfer the product at all to such a person unless he is first able to make it safe. It clearly follows, as I see it, that good ware must not sell a tire to a person who it knows will use it dangerously, and that it must be responsible for the consequence if a tire so sold is so used. And as well, some of the cases have indicated there's a duty on the part of a defendant to verify whether their warnings are being followed. I move then to Part E of the paper that deals with measures of recoverable damages. And the 16th question that I ask is, if the manufacturer purported to provide a manufacturer's guarantee as to his product's capacity or quality, is the warranty contractually available to the particular plaintiff, or in respect of its exclusions or limitations, may the manufacturer rely on them as against such plaintiffs? And I have provided in the formal paper a number of cases indicating that essentially, as far as the law is concerned, in most cases, a manufacturer's guarantee doesn't exist. It's a meaningless concept in law for all intents and purposes, although it's the foundation of commerce. There are exceptions, but that's the stark basic fact of the matter. If, however, you want to bring yourself into privity, or the manufacturer does, by requiring you to give him back a warranty card. The sending of the warranty card back can be held to create adequate privity. In one case, the manufacturer said, "You didn't send me back my warranty registration card, I'm not liable," and the court agreed. The 17th question relates to an important area. Did the plaintiff suffer only economic loss arising out of the lesser worth of the product because of its deficiency, or consequential loss of profits by reason of such deficiency, as distinct from consequential physical damage, whether or not accompanied by economic loss? You'll recognize that this is the problem in Rivtow. And essentially, after Rivtow, what we are left with is a situation where the user or consumer cannot sue the manufacturer simply because the product isn't worth as much or has to have repair dollars put out on it to make it work. The only instance in which the manufacturer can be sued by the consumer or user in the absence of contractual privity is if there's been an accident resulting in either personal injury or physical loss. I have followed that through in the case law for you and indicated, of course, it's distinguished where there is an accident, and in many cases the courts have striven to show that there's been an accident and there's been some consequential loss when the consequential loss is relatively minimal, in order to bootstrap the case out of Rivtow, which the lower courts obviously have never liked. It's been distinguished whenever possible, but it is still very healthy. Recently, the Ontario Court of Appeal in Robert Simpson said, since the principles set out in Rivtow have no application to an action based on negligent misrepresentation, the plaintiff should not be prohibited from proceeding to trial. In that particular case, the plaintiff was seeking to recover the cost of rehanging or resuspending part of a ceiling. No accident had happened, nothing had fallen down, just the product didn't work. They would have lost if they'd sued on a Rivtow basis for the product simply being deficient. But they sued for misrepresentation, and again, on a very narrow distinction, Rivtow was held not to be applicable to a misrepresentation claim. Lastly, in this area, I wish to draw your attention to a very significant recent decision this past year of the House of Lords in England in Junior Books Limited and Vichy Company Limited. In that particular case, the building owner sued a subcontractor with whom it was not in privity for cracks which developed in a floor. No accident happened, no consequential loss, just a product, namely the laying of a floor, which wasn't done as well as it ought to have been. In a 3-2 split decision, the majority of the House of Lords held that there could be recovery. It was a number of fairly lengthy judgments, and in those judgments they consider that if you started with Donoghue and Stevenson and Headley Byrne was number 2, that as far as they're concerned, this is case number 3. It's that significant in its importance. The issue was laid down in the primary judgment by their lordships. The issue is being, quote, whether the relevant Scots and English law today extends the duty of care beyond a duty to prevent harm being done by faulty work to a duty to avoid such faults being present in the work itself. There are several different decisions, and I may simply say they should be read with care in order to understand exactly what they are and are not saying. I will pick up just one paragraph later on in my lengthy discussion of this case. Lord Roskill, who delivered a majority judgment, viewed his conclusion as the next logical step forward in the development of this branch of the law. It may certainly be argued that in the ordinary transaction of purchase and sale of chattels distributed by major manufacturers, the purchaser, contrary to the general statement by Lord Roskill, does indeed rely on the manufacturer at least as much, if not more, than on the immediate distributor as to matters of product quality. The thrust of the concurring judgment of Lord Keith is simply to emphasize that there would remain a difference between the case of purchase and sale and the case of action by a user based in tort, as only the purchaser would be able to recover the, quote, price thrown away, unquote, amounting to the restitution interest as distinct from what has been called the reliance interest in damages. The majority judgment of Lord Roskill, however, clearly appears to justify recovery for the cost of repairing any defect in the product, without regard to whether the need to do so is related to averting economic loss, which was a precondition for recovery in the opinion of Lord Keith. Obviously, it's an important case that can be read with care, and it's very hard to appreciate precisely what it says in a short time. I've dealt with questions of remoteness of damage, with aggravation, with nervous shock in this context, and I'll pick up briefly one on punitive damages in a products liability case. As long as malice or recklessness has been shown, one trial judge stated that the conduct of a manufacturer would have to be in the use of inferior materials, the employment of completely unskilled workmen, or some such conduct, none of which is here suggested or established. However, there may be situations within that particular ambit where exemplary damages punitive damages could be obtained in a product's case. The concluding section of the paper, which I don't think I have time to go through with you, is more academic in its nature in that it evaluates the recommendations of the Ontario Law Reform Commission report on products liability. That report, in essence, recommends strict liability, notwithstanding that it suggests that we've virtually got it in most cases anyways. It's concerned about the existence of some anomalies and would rather have the theory right. And for my own reasons, I have extended some suggestions as to why, in my humble opinion, the reasoning involved in that aspect of the report is perhaps not entirely unanswerable. I think that's the time that I was allotted, and I'm grateful for your attention.